Hey y'all. There it is. Taking a poll. So, I don't know. Let's give them some time to get in. Hey y'all. Is the chat working? Can y'all hear me okay? The people who is here. All I gotta do is check my tablet, you know. But I want to make sure y'all can hear me. Testing, testing. Testies, testies. As they say. Can y'all hear me okay? Can you hear me okay? Hey Ella. Can you guys hear me, Ella? Okay. I'm trying. Where's my screen? Okay, hold on. I am not seeing my screen shared. Oh, okay. Now let me see. All right, there it go. Hey, hey y'all. Hi Maya. Hey Camilla. Hey Ella. Tanisha, good morning, good morning. Yeah, I was trying to see if somebody else was going to do it, but I guess I got to be the one to do it, huh? So this is Ari's last filing. It is basically the same below he just replied, but I'll read it to you anyway. Okay? Now comes the defendant, Quadajah Johnson, by her attorney, Ari Williams, and replies to the people's response to defendants Illinois Supreme Court Rule 604H, appeal from the order denying pretrial release. In support of her reply memorandum, defendant states as follows. Okay, good morning. Thank you, Ms. Smith. Good morning, Camilla Griggs. Good morning, Lynn Ross. So, on March 12th, 2026, Ms. Johnson filed defendant's memorandum in support of Illinois Supreme Court rule appeal. On March 19th, the Appellate Court of Illinois First Judicial Branch filed an order requesting defendant appellant to supplement the record with any exhibits, video, or otherwise that were before the circuit court in her pretrial detention hearings on or before March 25th, 2026. These exhibits were to be filed with the clerk of the circuit court. On March 20th, the exhibits were filed before the circuit court. On Ms. Johnson's pretrial detention hearings were personally delivered to the clerk of the circuit court. On March 23rd, the exhibits were impounded and available for review via Case Center. Hey, Chanel. On April 1st, the state upheld the appellee memorandum, people's response to the defendant's appeal from the order denying pretrial release. Now, number 6 says that defendant found significant discrepancies asserted in the people's response memorandum regarding the timely submitted video evidence and clear mischaracterization of the evidence presented in the circuit court. Hey, Chanel. And so, April 2nd, defendant appellant filed defendant's motion for leave to file a reply memorandum to the people's response to the defendant's appeal from the order denying pretrial release to ensure that all key irrelevant issues were properly briefed, clarified and addressed before the court. So basically all this is saying is she wants to clarify anything that the court may have questions about after the state filed their memorandum. Okay, and then in number 8, she's just basically saying that the court granted her, the time to file her memorandum in response on April the 3rd. Now, here's her argument, which is the same baloney refried, except she wants to pick apart at the state at this point. So, I'm sorry, I was smoking a cigarette, y'all. I had coffee, sorry. So it says, contrary to the representation made by the plaintiff appellee, Ms. Johnson's claim of self-defense does not have merit. That's argument number 1. And it does not. Okay? In response to Ms. Johnson's assertion of self-defense as to the incident that took place September 8th, the plaintiff appellee stated that the self-defense claim fails at the outset because the people are not required under the Pre-Trial Fairness Act, PFA, to disprove affirmative defenses such as a claim of self-defense at pre-trial detention hearings. The plaintiff or appellee relied on case law to support such argument. However, in doing so, it is important to note that plaintiff appellee provided an incorrect legal citation in reference to People v. Smith. Hi, Allison Smith Cooper. Now, what we're going to see in this motion is that basically she wants to argue all of the defense's case studies that they put in their motion, or whether it applies to Holly or not. She still hasn't submitted anything new. So she goes on to say, plaintiff appellee relied on case law to support such argument. However, in doing so, it's important to note that plaintiff appellee provided an incorrect legal citation in reference to People v. Smith. People v. Smith was cited using the caption for People v. Phelps. And it does not cite to Smith on paragraph 31. Plaintiff appellee then citing Phelps cited incorrectly in paragraph 34 instead of 31. This failure to correctly cite legal authority calls into question not only the substance of plaintiff appellee argument, but the use of legal authority as presented in this memorandum. So basically what she's saying is that the state used the wrong case caption for the case that they cited. I don't see how that has anything to do with Holly, but she elaborates further in paragraph 2. Even then, despite these errors, Ms. Johnson's self-defense claim does not fail at outset. Neither in defendant appellee's brief nor in this reply memorandum is there argument being made regarding the state's requirement to prove or disprove affirmative defenses at pretrial detention hearings. Rather, the self-defense claim is being raised to rationalize and explain the lack of Ms. Johnson's intent to commit the offense of murder on September 8th, as well as to illustrate the imminent danger Ms. Johnson faced by the deceased that day. So she's saying that because they used the wrong case, that it fails to show that Quadajah was in imminent danger of Romika that day, which is total bullshit, okay? Total bullshit. Notably, as brought forth in Smith, a claim of justification is, of course, relevant at a pretrial case hearing, at a pretrial release hearing. So she's saying that if he properly used the case context, you would know that this person basically claimed self-defense, and it was relevant, their claim of self-defense, in a pretrial release hearing. Doubt it. But let's go. Plaintiff appellee also argues that Ms. Johnson's claim of self-defense has no merit. It does not. However, there is sufficient evidence brought forth in the circuit court as presented on record demonstrating merit behind the self-defense claim. If that was true, then, hey Tion, if that was true in Love and Life Mail, Onika Spicer and Ms. Cooper, so if this was true, then she would have been granted pretrial release, right? If there was sufficient evidence brought forth in the circuit court as presented on record, why is she still looking for pretrial release? Because they didn't present anything good enough, obviously, so I don't even know why she referred to that. Essentially, it is a key issue in the above captioned matter and significant to Ms. Johnson's defense, sustained by evidence showing that on September 8th, 2025, Ms. Johnson was physically attacked by the deceased in danger of her life and was not by any means the initial aggressor. Not only had the deceased initiated threats of violence toward Ms. Johnson in the past, but the deceased alerted Ms. Johnson's grandmother of her intent to kill Ms. Johnson. So we can see here that, hey, what's up, Quadajah? Good morning. Hey, Mason. Hey, Ladina Carter. And Quadajah, shout out to Quadajah, baby. I see you when I came in for one of the errands yesterday. I say, where the hell you say? Quadajah, like, I'm at White Castle, around the corner from Carlos. Then he go to the scene. He like, she must have hid behind here when she heard the shots. I'm like, oh shit, this man then went to the damn Quadajah. Boy, look, I ain't got time to be locking and loading and shit all after the fact. You need to take a witness with you when you go out. These streets ain't safe like that. Okay, so we know from this statement, okay, that she's going off, Ms. Johnson was physically attacked by the deceased in danger of her life. It was not by any means the initial aggressor. That's basically Carlos' statement. Hey, Ebony. And not only had the deceased initiated threats of violence toward Ms. Johnson in the past, but the deceased alerted Ms. Johnson's grandmother of her intent to kill Ms. Johnson. We know that that's from the petition that Quadajah had, you know, for her no stalking, no contact order. So what this tells me is that Ari still ain't got shit. The only thing that Ari is working off of is the same thing that her client yelled out at the scene. Her order of protection and a CCL. And I'm not even kidding you guys. That is the only defense that Ari is working from. That's the only thing she has in her kit. Okay? That's going to be the only thing that she uses in trial. If this goes to trial, I highly suggest she don't waste us taxpayers' time and money in Cook County, but whatever they want to do. But listen to what I'm saying. She only has the defense of this no contact order that was granted by default, and she only has the petition in which Quadajah says that Romika sent these texts and was calling her grandma and all of this stuff, where she doesn't have any police reports that coincide with these texts and calls, you know. So this is all she has for her client's defense. You are so right, Bernice Thomas, because seeing that this is all Ari has, that girl is never getting out of jail with just this bullshit, okay? She's just not. So on the day in question, uninvited and unannounced, the deceased took it upon herself to make a U-turn and drive to where Ms. Johnson and witness 1 were stationed on Cermak. So why do she keep referring to Romika making a U-turn? You cannot shoot and kill someone because they made a U-turn. The police don't shoot and kill people for making U-turns. People make U-turns all the time. People make U-turns all the time. And seeing that there are cameras there, you know, I'm sure that the state can easily pull data to show how many people make U-turns right there. So she says, well, Mika made a U-turn to drive with Miss Johnson and witness 1 were stationed on Cermak. At 9:02, an individual called 911 to report 2 black women hitting each other across the street from the school on 22nd and Cermak. So she's saying that somebody called and said it was 2 black women hitting each other. So if they were hitting each other, you know, which I doubt, because the state says that there was no physical fight or any physical anything between Quadajah and Romika. The state already said that. And the state already said it's backed up by video. But she still wants to say that they had a physical fight. And this is damning to her client, because why would your client be engaging in a physical fight? It says that the 2 black women were hitting each other. Not that Romika was hitting Holly, that they were hitting each other. Now this is Ari's defense. This is Ari's memorandum. And she's going back to a call from an unidentified person that they never got in touch with again. Okay? It goes on to say, the unidentified caller further described that there's a black lady. She seems to be the aggressor. Okay? So, this is another alarming thing. Thank you, Ella, and thank you, the other person that sent the stars, Sheila Hutchins. Okay? Now, this is what kills me. Why does she feel like Romika, okay, is the only person that can be described as a black lady? Quadajah's black, okay? Anybody can look at Quadajah Johnson and see she black, okay? Romika is a black woman, easily identified as well as a black woman. So how can you say that the black lady, she seems to be the aggressor, is Romika? Is she saying because Romika is darker than Holly that Romika has to be the black lady who's the aggressor? Thank you, Winnie. How is this making any sense? Okay? That's like colorism. And that's very disheartening, seeing that Ari is a dark-skinned black woman. How is she like to be the one described in this as the black lady because she's the darker person? That's ridiculous to say. But anyway, she wants to use this as her line of a defense. So she says there's a black lady, she seems to be aggressor, but the woman with the green has the gun. So the ... in between the aggressor and but the woman with the green has the gun means that there were other words being said. It seems to me that whoever is the aggressor is the person with the gun. Okay? If you have two people out, irregardless of whether you give the description of there's a black lady, right? It would seem to me that if you're describing two black women fighting, arguing, whatever, that the person with the gun has got to be the aggressor, because it's a more aggressive type of confrontation once you pull a gun out. If you standing there unarmed, another person standing there unarmed arguing, and you're describing who's being aggressive, that's one thing. But if you're standing there arguing and you're unarmed and the other person has a gun, then I think it will be fair to say that the person with the gun is the damn aggressor. I know, Ebony, they both black. You know what I mean? Like, I would feel it's unfair, Ebony, for me and you to be arguing, right? And you lighter than me, you know, from your profile pic, right? And they say it's two black women arguing, and Ebony got the gun, but she want to refer as the defense at, you know, like I'm the aggressor because I'm blacker than Ebony. But Ebony got the gun though. You see what I mean? That's bullshit. That's bullshit. And it's colorism. And like I said, it's sad for her to be a dark-skinned black woman and feel that way. But whatever. You know what I mean? Show your shit for your client. Show how you really feel. So the woman with the green was Petitioner Johnson. The audio recording of this 911 call, hey now Leslie, was presented in a circuit court as an exhibit, illustrating to the court that there was an unidentified, disinterested witness who saw the deceased inciting violence and aggression toward Ms. Johnson on the date of the incident. Why is this witness unidentified? But she's relying so heavily on this witness's words. Actually, this person could not be a witness because they're unidentified. They're just an unidentified 911 caller, okay, who called through a text now number. We're going to go over that in this next paragraph. So it says the 911 call corroborates the fact that Ms. Johnson was physically attacked by the deceased. Who was the caller? And how can that corroborate anything only because witness one, who is Carlos, said something? Show the video. Show the video. It's a pod camera, a bus went by, it's multiple witnesses, but you only have Carlos and this unidentified caller from a text now number that's saying that Romika was the aggressor. Or she's basically using the person that called from the text now number words to try and manipulate them to say that Romika was the aggressor, even though the person said that the woman in the green had the gun. So it goes on to say that this person clarified that after a fight ensued, witness one tries to move his car. I'm going to bust that ass out. Just give me a second. I'm going to bust that out. So pay attention to this part, right? This witness clarified after a fight ensued, witness one tries to move his car. When witness one moves his car, okay, we know witness one is Carlos. Hell yeah, text now is sus as fuck, Sheila. This person clarified that after a fight ensued, witness one, who is Carlos, tries to move his car. Either he moved his car or he didn't move his car. Him trying to move his car makes it confusing. When witness 1 moves his car, that's when Romika attacks Miss Johnson and a shooting happened. She telling on herself. Watch. Miss Johnson's disheveled hair, as seen on video footage when the police arrived. So we all seen Holly hair when the police arrived. We all seen her on her phone talking to whoever the hell she was talking to. Her hair was not disheveled. Her hair, if her hair was disheveled, why was it still in a ponytail? Because if I grab your ass by your hair, bitch, you is not still finna have a ponytail. Make it make sense to me. Disheveled, but her hair is still in a ponytail. Disheveled, but she got braids, and then one of her braids snatched out her head. Okay? And all her braids, every single one is still in a ponytail. She ain't had no braids hanging out the ponytail on the side. She ain't had no braids hanging out her ponytail in the back. Every braid was in that ponytail. So make that bullshit make sense to me. Okay? Okay? And we already know witness 1 is biased because he Carlos. So here she goes. Miss Johnson's disheveled hair, as seen on video footage when police arrived on the scene, also cements the fact that Miss Johnson's hair was pulled and that the deceased physically attacked Miss Johnson. Now, ladies, we've all seen fights before. We all seen fights with women with braids. Now, I've seen a fight where of girls that got braids pulled from their motherfucking scalp. From the scalp, from the root. I've seen bad fights like that. Okay? This lady is not finna tell me nothing about her hair. Okay? And nothing about it being pulled, and none of that bullshit like that, when she just said earlier in her motion that they was hitting each other. Didn't she say they were hitting each other? That she got a call, a 911 call about 2 women hitting each other? So how is it just not? How is it about Holly getting her hair pulled at this point? Why was the bitch fight? Carlos had already had Romika in the hold. He had already hit Romika in the back with her own car door, forcing her in her own vehicle. And now, you mean to tell me Holly fighting Romika? And you think that's smart to say? So basically, they jumped Romika. Carlos fought her first, then Holly fought her next. Is that what you saying, Ari? Because what I know from all of this that you said so far was there was hella time for Quadajah to call the police. Hell, one of the witnesses that wasn't even there at the beginning, witness 3, called the police 2 times. Not only would you lose braids, Tion, but why was every single braid still in a ponytail? How the bitch rubber band wasn't even broke? What kind of rubber band she used? I need to use that shit for my 17-year-old daughter. Huh? So she say all of this is further supported by Carlos' statement to the police a few hours later while on the scene. Now what this is telling me is a few hours later, Carlos' ass was still on the scene with the police. and they questioned him on the scene. And he was on the scene for a few hours. A few mean 3. A couple mean 2. So a few hours is 3 hours late. If this happened at 9:05, 10, 11, 12, so at 12 noon, Carlos just now telling them on the scene that Romika ran up on Quadajah. And I've been saying that since the first motion that Ari filed. Why did it take Carlos hours to say that Romika ran up on Quadajah and swung on her? And swinging on someone doesn't mean that you actually hit them. I've seen plenty of fights where persons swing and miss. That ain't unusual. So make it make sense. Either she hit her or she swung at her. And by him saying she swung at her, that sounds to me like she swung and it didn't connect. So she obviously didn't hit her. Why didn't Carlos say that Romika pulled Holly's hair? Because Ari's saying that Romika pulled Holly's hair and her hair was disheveled. Why did Carlos only say that she swung at Quadajah? Why didn't Carlos say that she grabbed her hair and she did all of this shit? Why is Ari the only person saying that? Then it goes on to say, as such, the deceased posed a grave danger and incredible imminent threat to Ms. Johnson's life September 8th, wherein Ms. Johnson reasonably believed and felt it necessary to engage in self-defense and preservation measures. Now, let me read what y'all saying, because y'all going in the chat. Okay? Let me go back. So I already talked about what Tion's statement said. Tion said that if you win a fight, you're going to lose at least 3 braids, right? Ella says Meeks would have had braids in her head and she refused medical attention. This was all on live the first day. Why would Meeks have, she not going to have braids in her hand? Because no braids were pulled from Holly's hair. That's some dumb shit they said that Romika had. I don't even engage in that. You know what I'm saying? All that she had hair in her hands and all that stupid shit, you know? That's what y'all heard over there in the ops camp. Okay? You ain't seen that in no medical examiner report or police report or nothing else. Ebony says, and why, when Romika got back in her car, why the fuck did Holly start hitting her hood, baiting her to get back out the car? Exactly. She's doing all of this stuff, but she ain't calling the police. If you could go to somebody's car and bang on their hood, you can go to your car, grab your phone, and bang 911 on that. Okay? So, how is Romika causing all of this imminent danger and all of these imminent threats and everybody so scared of their life, as far as witness 1, which is Carlos, and Quadajah, the defendant? She's so scared, and her lawyer is trying to say, oh, she's so scared and it was an imminent threat to her life. It could never be an imminent threat to that bitch's life because she the one holding the gun. Let's be clear. It could never be an imminent threat to Holly Quadajah Johnson's life. It could not ever be a grave threat of danger. Any of that. None of that can ever apply to her because she's the bitch with the gun. Okay? I'm unarmed, right? And this a bitch I'm arguing with, fighting with. She got a loaded gun with hollow points the whole motherfucking time. She got a gun loaded with bullets that penetrate between 12 to 18 inches into a person's body. 12 to 18 inches is what these bullets are designed to do. She cannot ever be in grave danger or facing an imminent threat when she's the one holding the gun with them type of bullets. She's always the person with the upper hand because she's the one holding deadly force the entire time. And she knows this. Romika don't gotta know it. Quadajah knows that she's holding a 9mm with bullets that penetrate 12 to 18 inches into a person's body. She knows that she's armed with this weapon and these bullets the entire time. She left from where she lived all the way out at West Bubblefuck Waukegan and came to Chicago with this gun with these type of bullets. She did not even change her clothes. Some say that she went back home for dinner in that weekend and then came back to Carlos' house. Even if she did, isn't it alarming that she would do that and still not take time to wash her ass? Did she keep on the same clothes that she wore in social media while at Carlos' house to make herself easily identifiable to Romika? Because I don't know why, unless you just a funky ass motherfucker, would you wear the same shit every day as a grown woman with a baby? Did she change her baby clothes? Or was her baby in the same clothes for 3 days? This is a bitch who say, I stay Dolce and Gabbana down, but you don't even change your clothes. Is it okay to wear designer clothes 3 days straight because they designer? Aries, I already did a video about the bullets. That shit is not from his shorts. Please don't come in my chat talking about the shit is from Carlos shorts. That's some stupid ass shit. And I'm going to tell you why it's some stupid ass shit to say. Because his pants were mostly black. Them little pinstripe threads of red in his shorts don't even make sense. Make it make sense. The red is from them specialized bullets that Holly had. Please go back and look at my video so you will know where the red fabric came from and you won't be out here talking about the shit came out of Carlos fucking shorts. Okay? It's from the fucking bullets. Okay? Holly parked in that location to set her up. Absolutely. Absolutely. And he knew where she was going to be because everybody says, including him, okay, that she called multiple times that morning. She called him multiple times that morning and he ignored her call. Why did he ignore her call? Because he knew that they was going to be stalking. Why would he ignore her call? For her son to go to school right down the street. But it's not unusual for him to ignore calls when Holly's around, right? Why can he only be a dad when Holly not around? So let's go on, y'all. Plaintiff appellee argued that according to the statutory language of when a person commits first-degree murder, the court ruling should be upheld. Plaintiff appellee notes that defendant's intent to kill or cause great bodily harm was made clear by the fact she shot an unarmed victim point blank, pausing after the first shot to fire 2 more shots. Did that not happen? Yes, Felicia, she went to the car and got the gun. Why didn't she leave? Yes, La Leslie, who calls from a text now number? You have to go to the app to make the phone call? Yeah, that sounds real fucking strange. Real fucking strange. Well, you can't call 911 off the Text Now app, and the app doesn't allow you. Ooh, interesting. I'm gonna have to download that shit and see how it works. Yeah, she a bum. Yeah, she a bum, Chanel. Right, that's Felicia. That's what I'm talking about. With the child in the car, the gun was not locked up. Now tell me how much she cared about her child. And not only that, right? So, you know, if the gun not locked up, your baby in the car seat strapped in, most likely they're not going to be able to get out the car seat and get to the gun. But the fact that the gun was jammed, and you don't know how that will present itself, if the gun will unjam by firing the bullet, and you don't know how that's going to go, and you leave that gun in the car, jammed with a bullet in the chamber with your child in there, but you ain't even in there, that's fucking sick. Right, why those type of bullets, Ebony? And she didn't wake up that day. Whenever she woke up and bought them bullets was when she knew she was going to do what she was going to do. Those bullets are not designed for you to shoot someone and they live. Adrian says Lois and Quadajah didn't pull up together. Slow Holly slept in the car. Look, girl, I'm not even finna do that. Okay? I'm going off what I know is for sure. And if we find out anything else besides that, it'll be in trial. But I can only go, I don't introduce more fucking bullshit, right, to have us going in circles. Whatever's presented, I ain't saying that it ain't happened. Who knows what happened? But I don't have no evidence of that, so I ain't speaking on that. From what we have video evidence of, they pulled up together. Okay? So, I'm just reading these comments. And then we're going to get to the part, I don't even know why, we're going to get to this part later on, and I'll address it when we get to it. So, plaintiff appellee argued according to the statutory language of when a person commits first-degree murder, the court's ruling should not be upheld. Plaintiff appellee notes that defendant's intent to kill or cause great bodily harm was made clear by the fact that she shot an unarmed victim point blank, pausing after the first shot to fire 2 more shots. Absolutely. We seen with the case of Keisha Harris that, you know, they made a comparison about, and she was in Chicago on 112th and she used self-defense. It's a huge difference in Keisha Harris' case and Quadajah John's case. Number one, the biggest difference is that LaKeisha Harris did not commit murder. The person that she shot is still alive, and she shot that person one time, and you can physically look at LaKeisha Harris' physical attack, okay, because you can see the injuries on her face and on her person, and she went to the hospital in regards to her injuries, and we see that Quadajah refused medical attention. She didn't have a scratch on her. She didn't have a braid out of place. She didn't have a braid missing. She killed Ronika. She shot her more than once. She shot her until her gun jammed. And the type of bullets that Holly used and the type of bullets that Miss Harris used are totally different. Now, However, the above listed evidence supports the fact that Ms. Johnson did not have the intent to kill. Bullshit. Where Ms. Johnson was not the initial aggressor. Bullshit. In fact, she was attacked. Bullshit. How was she attacked when you said that they were hitting each other? An attacked person is only getting hit. She want to go off a text now, unidentified motherfucking person, right, that said that they were hitting each other. That contradicts what Carlos said. Carlos said that Romika swung on Holly. He didn't say she was hitting her. He said that she swung on her. That's one swing. That ain't even a hit. That's one swing. So how is she going to go off a text now number for an unidentified person saying that they were hitting each other? And then she says that Carlos said Romika swung on Holly. Like Holly didn't swing or hit her back, right? Now she's flat out saying that Ms. Johnson was attacked. That's some bullshit. In fact, she was attacked and used force that was self-protective in nature against the imminent threat posed by the deceased. To reiterate, the mere fact that multiple shots were fired does not negate the claim of self-defense. It does. How many shots does it take to stop the threat? Once you stop the threat, you're no longer in danger. The whole danger thing is bullshit. Because when I'm in danger, I call the motherfucking police. If I feel I'm in danger, if I feel I'm scared of an individual, I call the police. I don't go and try and fight the individual. Then go pull out a deadly weapon and kill the individual. I'm going to call the police and let them know what's going on. Okay? Plaintiff appellee further cited People v. Phelps to substantiate the argument that the defendant who shot an unarmed victim who did not threaten him was guilty of first-degree murder, and is. People v. Phelps, on the contrary, Phelps did not rule on guilt. This was an appeal of the trial court's order to detain the defendant. The court in Phelps said the defendant was not threatened with a weapon by the deceased, but there was evidence of the victim lunging at the defendant prior to the shooting. The appellate court in Phelps also based its determination that the evidence was clear and convincing that the defendant did not commit the offense of murder on surveillance video that showed the defendant shooting the deceased. There is no video surveillance evidence capturing the shooting in this case. Phelps is factually distinguishable from this case at hand. So this bomb Ari, okay, she's saying that the Phelps case is different, and it is, in the fact that Holly was not threatened by a weapon from Romika. That's true, because Romika did not have a weapon. Okay? And she's also saying that video evidence showed the defendant shooting the deceased, but there's no video that shows Holly shooting Romika. Girl, we don't need video showing her actually doing the shooting. When there's video that shows her with the gun in her hand after the shooting, when it's a confession of your client saying that she shot Romika. And this is the stupidest shit in the world. Because how are you even at this point trying to use the base of the... I mean, it's a legitimate argument because there is no video of the actual shooting. But it's fucking stupid because we know that Quadajah shot Romika. And in prior motions that Ari made, she argues the fact that there was no pause between the first and subsequent shots that Quadajah made. So how are you arguing that your client did not have a pause between shots and then act like because there's no video of the shooting, like that's applicable to any fucking thing outside of you arguing that that's the difference in the Phelps case? Quadajah killed Romika. Quadajah is the shooter. Every fucking body knows it. Everybody seen, heard it. She admitted to it. So fucking stop. Additionally, plaintiff appellee cited People v. Gage, People v. Johnson to prove there is no merit to Ms. Johnson's claim of self-defense and that the trial court properly found that there was clear and convincing evidence of detainable offense. Both cases are also distinguishable, okay, from the instant case. In People v. Gage, there's no present or imminent threat to the defendant by the unarmed victim. People v. Gage, in the above captioned case, the deceased absolutely posed a great and imminent and harmful threat to Ms. Johnson's life. Bullshit. Ms. Johnson had a gun. Ms. Johnson knew she had a gun from the moment she left her house in Waukegan to drive to Chicago to spend the weekend with Carlos, go all to the mall and stall until Monday morning, up to the point where she argued with Romika and subsequently shot and killed her. She knew she had a gun. How is this bitch scared? Okay, can y'all make this make sense to me? How is Holly scared of anything? And she know that she got a 9mm with hollow points in that motherfucker. This is how I know her client crazy. This is how I know her client crazy. How is she scared when she got a 9mm? Hey Frederica, hey Faith, hey Michelle. How was she scared and she got a 9mm with hollow points in it? I ain't scared when I don't got a gun. When I don't got a gun, I ain't scared. Give me a 9mm with hollow points, I ain't scared of shit. I wouldn't give a fuck what a motherfucker talking about. Talk your ass off. Talk your ass off. I ain't even finna argue with you. I'm loaded. I ain't even finna argue with you. Fuck, I look like arguing with somebody. I ain't got a gun to argue with nobody. I got a gun so I can walk away and be on about my business. Like I told y'all, when I was in the hood, around my grandma's, right, into it with them bitches in the racing court, and Shorty ran up on me, right? It's like 12 of them steady trying to fight me. I done called all their ass on the one-on-one and fucked the main bitches up. Right? Ain't nobody whooped my ass. But Shorty felt like she gonna run up on me with a brick. I know I'm motherfucking loaded. Right? I let her run all the way up and up that motherfucker 38. That bitch pissed on herself and dropped that brick. Ain't nobody finna do shit when you got no gun in your hand. But you gotta give them the opportunity to walk away. That she coming at me with a brick. A brick is a weapon. Right? I gave her ass the opportunity to get the fuck off. Now, This motion continues to say, additionally, plaintiff appellee cited People v. Gage, People v. Johnson to prove there's no merit to Ms. Johnson's self-defense claim. It's not. And that the trial court properly found there was clear and convincing evidence of a detainable offense. Both cases are distinguishable from the instant case. In People v. Gage, there was no present or imminent threat to the defendant by the unarmed victim. Just like there was no present or imminent threat to Quadajah, the defendant, by unarmed Romika. Okay? People v. Gage, in the above captioned case, the deceased absolutely posed a great, imminent, and harmful threat to Ms. Johnson's life. No, Ms. Johnson had the gun. Okay? Ain't no way in hell that Quadajah thought that she was in great, imminent, and harmful way of Romika. Okay? But yeah, I know Ebony, she could do a lot of damage with a brick. But here's the thing. My point in that is, you're not going to convince me that when you got a gun that you in fear. She had a brick, but I knew I was, bitch, a brick can't do shit with a blick. Okay? So I wasn't in fear. Okay? I knew I had the upper hand. You see what I'm saying? So, bitch, while you running up, check it out. This is totally different. Okay? How is she saying that her client is in so much fear and there's such a threat when her client is holding a 9mm Glock with hollow points in it? She wasn't in fear. She was in position to do what she wanted to do, like she posted she was going to do. They don't want to talk about the post she made, that sometimes you just gotta, thank you, Faith. Thank you, Faith. She provoked her to give a reason to use a gun. She knew exactly what she was doing, resharing the post on her Facebook. Sometimes you have to start killing a motherfucker. She definitely knew what she was doing. Yes. Yes. The most damning thing ever. Okay? Then she want to go on to say, in the above caption case, the deceased absolutely posed a great and imminent harmful threat to Ms. Johnson's life, evident through the deceased uninvitedly approaching Ms. Johnson, threatening Ms. Johnson on the scene by telling her, I told you I was going to catch you. She first said that Romika made the statement, I told y'all I was going to catch y'all, right? A threat is not, I told you I was going to catch you. You say that to a thief. You say that to a person who done already did some bogus shit. You say that to a person who you done caught in a lie. Told you I was going to catch your lying ass. Told you I was going to catch you. Told you I was going to catch you with that lie. And then seeing there was two people standing there, Carlos and Holly, how in the fuck she gonna say that she just talking to Holly? And again, how is I told you I was gonna catch you a threat? Where is the threat in I told you I was gonna catch you? I told you I was gonna catch you is not a threat. You know how many times as a substitute teacher I done had to tell a student, I told you I was going to catch you. You know, when you tell them to quit talking, but they still talking. Tell them to sit in their seat. They still running around up out their seat. I told you I was going to catch you. It's not a threat. Where's the, show me where it says, and I told you I was going to catch you. Show me the part where it's physical harm being threatened. Show me where the threat is, and I told you I was going to catch you. Then she says she rushes toward Miss Johnson, swinging at her. How? Okay, so Ari, you're saying that she was swinging. That's multiple swings at Miss Johnson. You didn't say she hit her. Just like Carlos said, she swung. Swung is one time. Swinging is multiple times. Swinging and swung does not equal contact. Either you hit somebody or you didn't hit somebody. I've seen plenty of people swing and not hit. She is really reaching. Really reaching. Both Miss Johnson and the deceased were aware that Miss Johnson was seeking an order of protection against the deceased. So what? And let's talk about it. You see what I'm saying, Ebony? Ain't no damn threat. Right, and why did she talk about I just dropped my son off at school? What? Right? Let's talk about it. Let's talk about it. And she constantly goes back to this order of protection, and that is damning on her client. Let me tell you why. If you think you're cooking with that order of protection, let me tell you why you're not cooking. Okay? I'm going to tell you why you're not cooking. Number one, you're not cooking with the order of protection because in Cook County, there's a civil order of protection and criminal order of protection. Explain the difference between a criminal order of protection and a civil no contact, no stalking order in Cook County, Illinois. Now, this is why she ain't cooking, okay? In Cook County, the primary difference between these orders lies in the relationship between the parties and a specific conduct being addressed. While people often use the term no contact order, generally Illinois law split these into three distinct categories. Number one, an order of protection. She ain't have no order of protection. This is for cases involving domestic violence. Relationship required. You must have a specific family or household relationship with the person. This includes spouses, ex-spouses, dating partners, co-parents, or people related by blood or shared housing. So that can be with Carlos and Ronika, but not Carlos and Quadajah, because they ain't in no relationship. They don't share housing. The criminal versus civil distinction. Okay? Quadajah Johnson had a civil no contact order that we're going to get to. Okay? CONVICT. CO. Number 2, she did not have a criminal order of protection. Okay? The criminal versus civil distinction. Civil, you filed this yourself. And we seen that Quadajah Johnson filed this herself or with an attorney. We seen she did not have an attorney file this case for her. She did not pay a private attorney to go in there and file a civil order for her. Okay? Criminal. This is requested by the state attorney as part of a pending criminal case like a domestic battery charge. We did not see her with a criminal order of protection. A criminal order of protection is done by the state attorney. Quadajah would have had to go to the police department. The police would have prepared a packet for her with all of the shit Romika has done to her. She would have took that sealed packet, which she is not allowed to open and look at, no matter how bad she wants to, must remain sealed. Take it to the state attorney. The state attorney will take it in the court and get her a criminal order of protection. That did not happen. Because the bitch ain't have shit as far as police reports and nothing substantial for her to have a criminal order. She had a civil no contact order. Okay? So she ain't cooking with shit. Cause she ain't have no what? Criminal order. She had a what? Civil no contact order. And in her civil no contact order, in the court transcripts, her dumb ass said she had Romika's mail. That's a federal offense. She also stated and basically asked multiple times that Romika be served at her son's school. So that shows that she had this sick ass infatuation with going to fuck with Romika at her son's school. Because, to keep it a buck, Carlos could have served Romika the order of protection. Well, the civil no contact order. Right? Carlos could have served that shit to Romika. Anybody could have served that shit to Romika. Quadajah could have called the police to Romika's job and had Romika served on her job. She didn't want that. Just like she didn't want to call the police the day she saw Romika. She wanted to shoot and kill Romika like she posted. So she ain't cooking with this motherfucking civil no contact order, and I'm tired of motherfuckers acting like she cooking with a civil no contact order, cause she ain't cooking with shit, cause she did not have a criminal order, okay, and it was granted by default. It wasn't granted while Romika was there, because the judge could have granted her the order when Romika was on the court Zoom on June 18th. She had been in court for that stalking no contact civil order since December, when they both were on the court Zoom in June. Wasn't the judge granted to her in June? Wasn't the judge granted to her in June when Romika was on that court Zoom? Because Romika came on that court Zoom and she defended herself and she showed and proved that she was fucking with her. That's why she couldn't get it June 18th. She could not get it on June 18th. She had to get it by default because Romika did not show up. Moving along, okay? I just wanted to show y'all the difference. Stalking no contact order. This is for victims of stalking. Romika ain't never been to the bitch house. Okay? A course of conduct involving at least 2 incidents that cause fear or emotional distress. Relationship required, none. This is frequently for neighbors, former co-workers, or individuals who are harassing someone they are not dating. What does it mean? It prohibits the person from following, monitoring, or communicating with you in any way. She was not following Holly, she was not monitoring Holly, and she wasn't communicating with the bitch. And hadn't communicated with the bitch in a long ass time. Okay? Because it would have been in our emotions that Romika had called Holly after the order was given and Dee saw that Romika had did this and Romika had did that. Ain't none of that fucking happened. So I just wanted y'all to know the difference between these orders. Okay? Comparison summary. Primary goal. Order of protection is to stop domestic violence. Civil no contact order is to stop sexual assault, abuse, or assault. Stalking no contact order is to stop stalking or harassment. Relationship in the order of protection must be a family, household, or dating relationship. In a civil no contact order, none is required. In a stalking no contact order, none is required. Common uses in the order of protection as partners, spouses, and family. Civil no contact, sexual assault by a person, that ain't happened with Romika and her. Stalking by neighbors and workers, that ain't happened with Romika and her. Key relief, to stay away, custody or housing with the order of protection. You need all that, right? You need all that. In the civil no contact order, they just want you to stay away from them, right? But you're supposed to stay away from them as well. And Romika was staying away from her. She's where Romika drops her son off. Where she had in the court transcript that she was in pursuit of an order, that she wanted the order to be served upon Romika. Okay? Okay. Alright? So she wasn't at 555 West Harrison. Okay? She was out in Skokie getting a stalking no contact civil order. No criminal, nothing was involved. Okay? Alright. Now we back on this. Okay? Because I just want y'all to know, out here in these streets, when y'all hear them heavily rely, and when you see this attorney heavily rely on this order, civil no contact order, that she ain't cooking with shit. That it's nothing. She didn't even have a criminal order. The bitch ain't have shit. She shot Romika with a punk ass civil order that was granted by default. We see that the order of orders is a criminal order of protection. She didn't even have that type of order. She had a civil order. We see that's for neighbors who have disputes, and it's basically that you want people to stay away from each other. That you want that person to stay away from you. Okay? She did not have a criminal order of protection to where, everybody's involved, like the state attorney and the cops, because she's been harassed. Don't let them fool you. I just educated you guys with the proper terminology, with proper facts as to how it goes in Cook County and the levels of orders that it is. Okay? So, whenever you hear that mentioned, civil order of protection, you know that they are blowing smoke up your ass, and they just waving the same dumb shit that Quadajah was waving when the police came to the scene. All Ari is saying in her motion is the same thing Quadajah was saying at the scene. I got an order of protection and a CCL. Bitch, you didn't even have an order of protection. You thought you had an order of protection, which dumbass, because you can't spell first. You spell it frist. F-R-I-S-T. So you probably thought you had an order of protection. You did not. Maybe her family thinks that she had an order of protection. She did not. She had a civil no contact order that was not violated. Matter of fact, this bitch feeling bold. She out looking for shit. She at the school where she wanted the sheriffs to serve Romika. Now she's taking it upon herself to be there fucking with Romika. Instead of being in an argument with Romika, instead of stalking Romika and killing Romika, bitch, if you wanted to do the right thing, if it was all about being righteous, why didn't you sit with your armed ass, with your 9mm Glock and hollow points? Why didn't you sit and stand down till the police came? Oh, bitch, you can't tell me that you pulled out a 9mm and somebody wanted to still fucking argue, fight, or even be around your crazy ass. Ain't no way, bitch, you got a 9mm. Okay, and you got a vehicle. And you got your baby with you. You could have drove to the police station, told the police y'all got into it, or whatever dumb shit you was gonna say. Okay? Carlos know where Romika worked. The nigga done been up there a million times on bullshit. The police go up there. Her job is not finna lie and say she ain't there. Okay? And all the police would have done was serve Romika with the order because she had not been served. She still wouldn't have been in violation. That's how I know that's not what you wanted. Nor do I think she thinks or her thought process goes that far. Okay? Now, I left off with this fake ass statement that says that Romika threatening Miss Johnson on the scene, telling her, I told you I was going to catch you, rushing toward Miss Johnson and swinging on her. Can y'all take some swings in the air? Let's just take some swings in the air, y'all. Just swing. Just punch in the air. Because that's what swinging looks like. She ain't say she hit her. She said she was swinging. And how do we know that she was swinging at Quadajah? Because there's a statement saying that Romika had her arms flailing to get out of Carlos's grasp. So is that the swinging she talking about when she was trying to get loose from Carlos? And how was Carlos moving his fucking car, right? How was Carlos moving his car when Romika attacked Quadajah? Because the storyline goes that from the witnesses that Carlos had Romika in a chokehold. Romika wiggled out, and as soon as she wiggled out, Holly fired and shot Romika. Okay? It ain't say shit about he was moving his car, and then they was fighting, and then Quadajah shot Romika. No. None of the witnesses said shit about Carlos moving his car until after Romika was shot, maybe. I didn't see Carlos' car moved when the police was there. I still saw his car in the street. I didn't see his car parked. Maybe I missed it. So this is how I know this is some bullshit, okay? It don't even matter if it was granted by default and never served. That's a punk ass piece of paper. She did not have a criminal order. Okay? She did not have a criminal order. Both Miss Johnson and the deceased were aware Miss Johnson was seeking an order of protection against the deceased. So, and Miss Johnson and Romika were both aware because the judge told Both Romika and Quadajah, and it's still in the court transcript, that Romika had 30 days, and I believe she has more than that, to have the order dropped after it was given by default. Okay? So I don't know why they keep acting like this civil order is something like a criminal order of protection, but it's not. And no matter what the fuck she puts in her motion, you cannot ever make a civil order of protection in which she got it by default, and it took her damn near 8 months, okay? Just as long as it took her to have a baby to get the motherfucker. Alright? So, it says, in People v. Johnson, the defendant shot at the victim and kept hunting and chasing down the victim, shooting that individual at least 7 more times. In the present case, Ms. Johnson did not pursue the deceased in such manner, nor did Ms. Johnson shoot more than 3 times. Guess why? Guess why? Because Ms. Johnson used hollow point bullets, and when she shot the victim, these bullets mushroom and penetrate. When they get inside your body, they go 12 to 18 inches and basically explode. And shrapnel breaks off, as we seen from my video. Small pieces of metal breaks off from these bullets and go throughout your body. Right? So when she shot her in the leg, right, in her femur, the largest bone in your body, Google it. Because I went to the University of Chicago Pritzker Medical School, and they paid me to go there. I also got an A+ in forensic science. I also took pre-law. I didn't pursue law, but I took pre-law because I thought it was important in medicine to be able to explain malpractice. But anyway, that's a whole nother subject, right? So, whether she shot her in the face first or her femur first, either one would render Romika motionless and helpless. Both are fatal shots. So, if Ari wants to argue that first Quadajah shot Romika in the femur first, okay, she does not have to, she's not going to chase Romika down because you're not running anywhere being shot in your femur. You're not going anywhere. You're not running. You're not going to even be able to hop on your other leg. Your balance will be just, you won't be able to, you aren't going anywhere shot in your femur, so how's she going to pursue it? Okay, let's say that she shot Romika in the face first. Someone is shot in the face. You're shot in the face with a 9mm, with a bullet, okay? We all see Romika is a very petite girl. Okay? Romika does not have this huge head. Okay? Her head matches her body in proportion. As stated, these particular red tip bullets go 12 to 18 inches deep. Do you know how deep 12 inches is? 12 inches is a yard. Right? How long is 12 inches? You look at it on a ruler. How long is 12 inches deep? So you get shot in the face. Where are you going? Why would she pursue Romika after she shot her anyway? Why would she be in pursuit of Romika? Romika didn't have the type of wounds to where she could still be running or still be in movement. So she could not ever be in pursuit of Romika with 2 kill shots. And then she says, nor did Ms. Johnson shoot more than 3 times. Ms. Johnson did not shoot more than 3 times because her gun did not allow her to. Ms. Johnson's gun jammed and she could not shoot her more than 3 times. Had her gun not jammed, she would have shot her till she could not shoot anymore. Obviously, she was pulling that trigger like she lost her fucking mind and very swift for her to jam her own gun. But an expert has testified to that. An expert will have video of them going to the gun range and firing a 9mm with those type of bullets and showing that she had to really be firing. She had to be really pulling that trigger as quick as she could for her to jam her own gun. Or that those bullets aren't designed for that gun. Anyway, that's a poor argument. She assassinated Romika, so how is she going to pursue her? 2 fatal shots, where was she going? And that brings me back to when these motherfuckers were saying early on that when Quadajah shot Romika was still running up on her. That dumb shit. That dumb shit. So in the next paragraph, okay, and that's why I checked their bullets with fatal shots. Cause what are you saying? You ain't saying shit. Ultimately, the evidence proving Ms. Johnson was physically attacked by the deceased on the date of the incident and that Ms. Johnson faced an imminent threat of death or bodily harm at the hands of the deceased directly contradicts the plaintiff appellee's claim that the evidence does not support a self-defense claim and that such claim has no merit. It doesn't. Because Ms. Johnson had the gun, she's the author of death, and the only person that was in imminent danger of death or great bodily harm was Romika Blackman. Quadajah knew she had the goddamn gun and the bullets. You see how they lying every day? And every day, I know you've been there day one. I know a lot of people in this chat have been there day one. They crazy. Are y'all listening to this? And you don't even have to be there day one to know this is bullshit. So they're not going to get away with telling the courts this. I know her intentions were to kill Romika because she posted that sometimes you just gotta start killing motherfuckers, and she killed her the first time she seen her. After she got the order. After she got the order, because bet him up. Amora wanted to point out that Holly was upstairs when Romika was arguing with Carlos about not picking up Little Losa when she was going to hit him with that piece of wood. Why ain't Holly come down there? Because she ain't had that motherfucker order of protection. She thought it was cute. But what did Carlos say? He was going to beat Romika's ass. But he did it. He did it. Because he wanted to catch Romika at a vulnerable moment, at a moment when she was upset, like he did every other video that he's put out. Every video that Carlos has put out of Romika being angry, Holly was involved. She was on the phone in that hotel room. She was on the pull-up and around that day on Juneteenth. She was upstairs when he didn't pick up little Los. All of these times he recorded Romika being angry. It was to protect Holly because he knew that bitch was going to kill Romika. And motherfucker, that shows premeditation on your part, which will be picked apart on that stand, and your ass going to jail because there is no statute of limitations on murder. And your ass conspired. And those videos show you conspired. Or else you would have never took. Okay? So here we are, part 2. Plaintiff appellee failed to review and consider the videotaped evidence included in the record on appeal. Bitch, you ain't had no videotaped evidence. Where is it? Where is it? Plaintiff appellee made numerous mentions in its response memorandum that defendant failed to supply the videotaped evidence on the record on appeal, and that any doubts arising from an incomplete record must also be resolved against the appellant. Correct. Where's your video evidence, Ari? You want to refer to video, but if your video, right, is just showing Carlos, witness 1, telling the police that Romika swung hours after the incident, that's not video evidence of Romika attacking her. Bitch, quit playing. It is important to make clear for the Honorable Court that the videotaped evidence and all other pretrial exhibits presented at the Circuit Court hearing during Ms. Johnson's detention hearings were provided in a timely manner and in accordance with this Court's March 19, 2026 order. Where are the videos? What videos did you submit? You don't got none. Anything submitted at the circuit court level was not enough to get her out on pretrial release, as it will not be enough on the appellate level. That's why you did not include those videos. But you steady want to refer back to videos like it's videos of the incident. Carlos saying Romika swung on Holly is not a video of the incident or a incident of Romika attacking Holly. Bitch, that's just a fucking video of Carlos making a statement. So where's the fucking video? There ain't none. Because you already stated in motions that it is none. It is important to make clear for this Honorable Court the videotaped evidence and all other pretrial exhibits presented at the Circuit Court during Ms. Johnson's detention hearings were provided in a timely manner and in accordance with the Court's March 19, 2026 order. Defendant appellant duly conformed that this Court's request and filed the necessary exhibits ahead of the delineated March 25, 2026 deadline, and such a sufficiently complete record was provided. No, I don't think it was, because just so happens that I looked at the exhibits because you left them public, right, because your dumb ass e-filed them, and they were public, and I was able to go upstairs on the 5th floor of the criminal court building and review the exhibits, in which I saw no videos. So you full of shit. Not to mention the fact that they've been on YouTube, right? Plaintiff appellee's response memorandum was filed on April 1st, 2026, so the state filed their response on April Fool's Day, right? Solely relying on the state's proffer. So they're saying that the state solely relied on the proffer. The state didn't solely rely on the proffer because the state also talked about the witnesses' testimony. The state also talked about video, okay, that they had, and they wanted to know why you didn't include video in your shit. Alright? And so in arguing that the defendant appellant premised their argument on videotaped evidence not included in the record on appeal. You did it. The defendant did not. Well, okay. In arguing that the defendant appellate premised this arguments on videotape evidence not included on the record on appeal. Well, Ari, if that's not true, where's your videotape evidence? Plaintiff appellee failed to review or consider the supplemental record, which is central to the facts in the case. What's the supplemental record? There is no, first of all, outside of the discovery with the ballistics and DNA testing and all of that, there is no supplemental records. Then she goes on to say it's clear that the plaintiff appellee did not consider the scope of all evidence as presented, and in such its arguments are limited to the proffer being forth in the circuit court, and fails to capture and articulate the facts and nature of this case on its own. Did she not see the witness statements? Did she not see that the state said that they have video from the bus? The state relied on multiple witnesses. Ari is only Ari. The state ain't just relying on a proffer. The state relied on a proffer, the witnesses, video evidence of where you were saying the witnesses were. When they had witnesses crossing the street at a point that you said they were further down the street. So we know that the state has used more than a proffer. The state has used video and everything else. You're the one that can't come to the table with video. You're the one that can only go off of witness one, which is Carlos, and some unbeknownst person from the Text Now app that called 911. And you had to make Holly a white woman to do that. So what the fuck are we really talking about? Okay? So she goes on to say, certain arguments as raised by plaintiff appellee must be addressed and corrected. Really? So she's saying plaintiff, which is the state, for instance, asserted that Romika's car was in front of Ms. Johnson's car and never blocked it, alleging that Ms. Johnson was free to leave at any time during the encounter on September 8th. And was, you just, check it out, dumbass Ari. Listen to what she just said, y'all. Listen to this gaslighting dumb shit. Okay? She said, for instance, asserted that the deceased car, okay? So, for instance, asserted that Romika's car was in front of Ms. Johnson's car and never blocked it, alleging that Ms. Johnson was free to leave at any time during this encounter on September 8th. Now, didn't this bitch just tell us, yeah, she a liar, Frederica. Check this out. This page 7. Y'all remember this page 7. Okay? Now, just up here, okay, she said that when Carlos moved his car, that's when Holly was attacked. Didn't I just read that? That she said when witness 1 moved his car, that's when Quadajah was attacked. That's when her and Romika had a fight. Okay? And that's what I'm looking for right now. here it is. However, up until the point where witness 1 moved his car, okay, witness 1 car and a deceased car prohibited Ms. Johnson from leaving the scene at any given moment. Okay? Now, I'm back at 7, but I meant to go ahead of that, right? Because she stated that when Carlos moved his car, that's when Romika attacked Quadajah. That's when Quadajah and Romika had this fight. Now, why wasn't she able to move her car if he moved his car? Because she still had to go to her car to get the gun. So when Carlos moved his car, the shooting occurred in response to the deceased rushing to attack Ms. Johnson while witness 1 was moving his car. So all the witnesses said that Romika was in this hold by Carlos. And when she broke free from the hold, that Holly shot her. So they saying that when Romika broke free from the hold of Carlos, that Carlos said, "Oh, let me go move my fucking car." And then that's when her and Holly got into it, and then Holly shot her. Bitch, you lying. Too many lies. Too many lies. Too many lies. He did not go move his car. He was still standing there when she shot Romika. The motherfucker didn't go move his car. So then she goes, evidently Ms. Johnson did not have the opportunity to get inside her car and leave the area until after the shooting already transpired. If Ms. Johnson had to go to her car and get the gun, bitch, and you saying that witness 1 was moving his car, okay, and Romika attacked Quadajah, okay, how did she get in her car? She got in her car to get the gun and shot Romika from the sidewalk, so she was able to get in her car. The bitch was, even if she was able to get in that motherfucker from the passenger side, the bitch was able to get in her car. Okay? And so you just scooch to the driver's side, bitch. Okay? Start that motherfucker up and go. I know Ebony, she the only dumb bitch talking about she was blocked in, then she wasn't blocked in. Make up your mind. Okay? She ain't blocked in to suit your story when you want it to. So she's saying Ms. Johnson's car was blocked. She was not free to leave and remove herself from the hostile, violent situation that the deceased created. How did Romika create a violent, hostile situation when she was held hostage and the violence was committed upon her? Carlos held her hostage by holding her in a chokehold, whatever hold he wanted to have her in, and her having to wrestle away. He should not have held her, period. Romika was attacked at her car. He slammed her car door on her back and forced her into her vehicle. Okay? She was the only one in a hostile, violent situation because all the hostility and violence was committed upon her. Alright? All of the violence and hostility was committed upon Romika. She swung on who? She was hit. multiple times by Carlos Smith. She was held by Carlos Smith. And then as far as Ari's motion, she's the only one saying that Quadajah was attacked. And then she says she could prove her client was attacked because her hair was disheveled. Where this shit has so many holes in it, it makes no sense. She's claiming a physical fight, then claiming that Romika only swung, then she's claiming that her client's hair was disheveled, so that proves the attack. That's just the stupidest shit I heard in the world, because we all seen her client when the police arrived, and every single braid was still in that ponytail, and every single braid was still attached to her head, and no one said there was any physical attack whatsoever, including her client. Have you guys noticed that in none of Ari's motions does it say that Quadajah said that Romika attacked her, that Quadajah said this is how the fight went? It only say witness 1 Carlos said that she swung on her. It only says some unknown person called from a text now phone. It does not ever state that Miss Johnson, Quadajah Johnson, told Ari Williams that Romika did a motherfucking thing to her. Absolutely. Let's not forget that Romika's thyroid was swollen. That had to be a hell of a chokehold. Let us not forget that those bullets traveled, okay, to her spine. So how could she pursue somebody who's not moving and running anywhere? Okay? Romika could not even talk. If Romika could talk, she would have told the police that bitch shot her. Okay? So then she says the state relies on accounts given by witnesses 3 and 5. No, by witness 3, 4, and 5. 2, 3, 4, and 5. Okay? Plaintiff appellee started with witness 5 to support an allegation that Ms. Johnson was aggressive and provoking the deceased. Okay. Witness 5 says she was threatening and provoking the deceased. And so she says witness 5 is not a credible source. Why? Not only was witness 5 allegations not included in the original proffer made by the state, but witness 5 was watching the incident from her car, then from her workplace on Cermak when she saw the deceased arguing with Ms. Johnson. So this tells me this person has watched the altercation go on for a long ass time. How do I know that? Because first witness 1 was watching the incident from her car, and then she was watching it from her workplace. So for a person to watch some shit go down from their car, go into work, and continue watching it, that tell me that Quadajah Johnson could have been called the motherfucking police long time ago or been left the scene. In its reliance, statements given by witness 3, plaintiff appellee argued that the deceased freed herself from witness 1 grasp and stepped away from Ms. Johnson. So yes, witness 3 said that Romika freed herself from Carlos' grasp and then stepped away from Ms. Johnson. Okay? Though the statements as alleged by witness 3 contain gaping inconsistencies, bullshit. No, they don't. And so she says, for instance, it is not alleged by any other witness besides witness 3 that the deceased took steps away from Ms. Johnson prior to the shots being fired. So what? That's witness 3's account of the event. You don't know if the other witnesses gonna agree to that. Maybe they didn't see Romika stepped away. Witness 3 had an excellent view of everything. Okay? And so she said instead it's been brought forth that mere moments before Miss Johnson shot at the deceased. No, she shot the deceased. She ain't shoot at her. She shot her. That the deceased rushed toward Miss Johnson to attack her. So here's the thing. She's saying that Romika already attacked Holly and that they already had a fight. So if they already had a fight, she already know that she ain't gonna do no damage. Cause it still wasn't no motherfucking damage done that we could see when we were watching the video after the fight. So what in the fuck is she talking about? What is she talking about? I don't care how many times she write this shit down. You will not ever make me believe that it was a physical fight between those two. And if it was one, it was mutual. There's no evidence of that. The only physical violence was between Carlos attacking Romika. Okay? Witness 3 is the only one who mentions anything about Carlos and Quadajah engaging in the fist bump shortly after the... We've seen the video of the fist bump. So she ain't the only fucking one. Everybody who's seen that video seen the fist bump, including the judge. So hold that shit to your chest. Maybe your dumb ass the only one that ain't seen the fist bump, Ari. But everybody else seen the fucking fist bump, okay? Including me. The video evidence supplemented on record illustrates very clearly that Witness 3 was walking in the opposite direction from the incident when leaving the CTA bus stop, and Witness 3 view of the incident was subsequently obstructed by the CTA Green Line building. Bitch, that's what you want to say. It's no way her shit was obstructed, because you know how I know? Because the crossing guard and Witness 3 crossed the street together on State Street. Okay? Because plaintiff appellee failed to consider and rely on videotape evidence provided in the supplemental record, plaintiff appellee arguments are supported by inconsistent, unverifiable allegations by Witness 3 and 5 as denoted and outlined in written appellate record. No, it's not. No, it is not. No, it is not. It is from video evidence that they have of the scene. Moreover, plaintiff appellee mischaracterized very valuable evidence pertaining to one of 3 911 calls made on the date of the incident. Defendant argues that one of Witness 3 calls to 911 suggested the victim was the aggressor in the scenario. However, the written record as well as the supplemented exhibit made clear that the 911 call being referred to was not made by Witness 3. Witness 3 made 2 phone calls to 911 where she reported that Witness 1 was slamming the deceased with her own car door, and the other call articulated that the shooting took place. There was an additional 911 call made at 9:02:29 a.m. in which the date of the incident by an unidentified person who would not leave their name. This person could be heard via the supplemental exhibit included in the appellate record suggesting the deceased was the aggressor. So we back to that. We back to the black, y'all. We back to the black where Romika the black and Holly the white, okay? That's why she wants this case taken out of Cook County. So she can tell them white folks that Romika black and Holly white. What the fuck? This bitch crazy, y'all. You the only one mischaracterizing anything, Ari, because you want to make Romika black and Holly white. Romika the black aggressor and Holly is in the green jumpsuit with the gun, and she ain't the aggressor because she light and white, right? Is that what you're saying? That's what the shit is giving to me. That's what the shit is giving to me. I don't know if it's giving it to y'all, but that's what the shit's giving to me. And that's what the shit is going to be given to the court. Okay? So she says that, the plaintiff appellee mischaracterized the evidence on account of not relying on the supplemental record, and it is vital for the defendant appellate to urge that the required corrections and clarify the issues presented to the plaintiff appellee's brief. So she's saying that she has to correct and clarify what the state said, because the state obviously must be lying. And then she goes on to say, in number 3 of her argument, that the state failed to show by clear and convincing evidence that Ms. Johnson poses a real and present threat. Any bitch shooting down the street at 9 in the morning with a 9mm instead of calling 911 is a fucking threat. And not only is she a threat, but the bitch is crazy. I'm going to say it again for the people in the back. Anybody with a 9mm gun that chooses to shoot and kill instead of calling 911 at 9 a.m. is a threat. That was my mom calling, y'all. I got a text. Hold on. And so, we go on here, right, for her to say that the state is failing to show that she poses a real and present threat. Anybody shooting at 9 a.m. with a 9mm is a threat. Okay? Then it goes on to say, specifically, plaintiff appellee points to section 6.1 G3, focusing on whether a defendant poses a threat to the community at large and to the witnesses in this case. However, Ms. Johnson does not pose a threat neither to the community at large nor to any identified individuals. You know why they're saying she don't pose a threat? Because she killed who she wanted to kill. That shows intent, that shows premeditation, it shows first-degree murder. Why is she no longer a threat to the community? Because she killed Romika Blackman, and that was her goal. So now everything is okay. Everything is fine. Everything is copacetic because Romika is killed by Quadajah. So Quadajah has no problems, everything is hunky-dory, everything is okay in her world. She is no longer a threat. She will no longer be shooting down the street at 9 a.m. on a school day across the street from a school because she feels a certain way. Right? She didn't get beat where she had to defend herself in that type of manner. Nothing occurred to where she needed to pull a gun out at all. Why did she even pull a gun out? Let's start there. Why did Quadajah even pull a gun out? She had argued, and this event had went on to the point where witness 3 had been able to come up on the bus, not even her own vehicle, on the bus, and see this altercation and call the police twice. Witness 3 could not have been on the scene before Quadajah, yet she called the police twice. Other witnesses called the police. Witness 5 seen the incident. Another witness seen the incident and was able to go to work and view it. A DoorDash driver in their vehicle was able to view the incident again, go into a cafe and still view the incident. This is how long this incident took place. And her client still has not called 911. But her client said, somebody please, didn't Quadajah have a video? These people are sick. Somebody call 911. Bitch, why didn't you call 911? You know what the numbers are. You did a video. Right? So, she says, however, Ms. Johnson does not pose a threat neither to the community at large nor to any identified individuals. Well, she didn't give a fuck if she let her gun off at 9 in the morning while children are going to school in the community. She said, fuck the community. She feel how she feel. She locked and loaded. She knows she got bullets in her gun that will penetrate 12 to 18 inches. Okay? That means those bullets can go through an individual and into another individual. That means that those bullets could have went through Romika and kept traveling. But most likely, those bullets will explode on impact. Okay? So now, they're saying that she's not a danger to the community. But she was shooting in the middle of a busy, wasn't it Monday at 9 a.m.? Maniac Monday? One of the busiest days of the week, but she ain't a threat to the community. She just come across the street from one of the best schools in Chicago and the bitch started shooting. Down the street from Chinatown, which is a huge tourist spot. Have you ever seen how many people are on Cermak right on the other side of that viaduct in Chinatown any given day? Bet you it's plenty of tourists. She don't give a damn. Then she says Ms. Johnson spent 87 days not in custody. And what did I say? In which the bitch antagonized the victim on social media and filed a lawsuit on Raphael for money in November. What was the bitch doing while she was out 87 days? Sitting behind the scenes, antagonizing the family, sitting behind the scenes, having Quadajah rep for her and feeding him information, her and her auntie. She sat behind the scenes doing that bullshit so long that they attacked Quadajah. The little dude who was willing, first of all, Quadajah the youngest one out the group. He the youngest one out the group, and they sent him forward to defend this murderer. And he was under the impression that these super grown niggas wasn't lying to him. And they was. And they was. Right? And so for 87 days, what was this bitch doing? She was on social media. I believe she was the one that called in the Key Station japping. Okay? She was definitely for her man, right? She took out time to take this nigga Raphael to court, okay? For some money, who knows where it came from? Because it's either she was being pimped by this nigga Raphael, or she was being pimped by Carlos some more, going out there trying to get money that he done got on a scam end back from somebody else. Okay? What else was she doing in them 87 days? She wasn't taking care of her business, and this little bullshit school, this little dental school, this ain't no fucking real fucking school. This is a 12-week program where people go to 2 years to be a dental assistant. This bitch thinks she could do it in 12 weeks at this fly-by-night ass school, okay, that she ain't even had the money for, that she didn't even apply to till after she killed Romika. Bitch, why weren't you trying to complete a 12-week program before you was trying to complete a CCL class to go kill somebody? Because you a fucking bum. It say that you got SNAP benefits and that your cost $700 a month and that you emptied your bank account to get this nigga Raphael your last. This is what this bitch was doing in her 87 days of freedom. Okay? It don't say that she was taking care of her child. It don't say that that bitch enrolled little Carson in motherfucking daycare so he could learn something. It say this bum ass bitch enrolled in a 12-week course after killing somebody so she can have something on paper like she a productive citizen. Yeah, I've seen the exhibits. All the exhibits are screenshots of text that Carlos sent Holly that he had no business sending us shit. Just like he ain't had no business recording for her. That's why his dumb ass going to jail. That's how I can tell he a little slow. And he in need of help. Because motherfucker, your dumb ass recorded all the volatile incidents that involve you, Romika, and Holly. Your dumb ass sent Holly all messages that related to any volatile or anything that said that Romika didn't like Holly. You sent it to Holly in advance. Why? You fueling the fire. Why? But you trying to portray yourself as a diffuser and a peacekeeper. No way in fuck you a diffuser when you send in texts to the other woman. You're stupid. Okay? And you carrying bones. And you recording yourself being the main catalyst in this murder. And still recording yourself with your dumb ass. Boy, you are dumb as hell. You 40 years old. You the oldest out of everybody. You looking like, let me tell you how you looking like. You looking as abusive as R. Kelly, P. Diddy, and any other sneak freak domestic violence motherfucker that they have recently locked down for the public to see except, nigga, you ain't got no album, no CD, no deal, walking around this motherfucker looking a mess. You look a mess. Anyway, that's what she was doing for 87 days, okay? It says, Ms. Johnson did not commit new offenses, nor did she present a danger to anyone in the community. As long as that bitch was free, I felt like the community was in danger. I felt that Little Los was in danger, that she might come back up to the school, that she may... When I seen that video of a female walking Right, when I was asking Quadajah about that video, when I was seeing the video of the female walking to the school and I seen that shadow on the ground, I legit thought that was Holly. Still do to this day. Okay? That's how much of a danger the bitch put in my mind. Okay? So, them saying in 87 days that she did not commit new offenses, how could she? Nor is she a danger to anyone in the community. She don't live in the community. She don't live here. So how can she be a danger? If anybody seen her out here, her ass would be in danger. The only way that bitch was coming back to Sumac was in the trunk of a car under a blanket in disguise for Halloween. That motherfucker wasn't just out there, right? Or was she? Was that her at the school? She was damn sure a danger to the community. Except she don't live in a community. She live all in West Bubblefuck Waukegan. She don't got a problem with nobody in Waukegan. Okay, she don't want to lose some motherfucking houses. She ain't got no problem with them people out there. Her problem was with Romika Blackman. And the only way she knew to find Romika was at that school. And that's what made her a danger to the community. And she was a danger then, she a danger now. She does not, let me be clear. She does not stop being a danger because she killed Romika. And that's all this shit is saying to me, and this is how it's reading off in my mind. That she's saying that she killed Romika. The problem was with Quadajah and Romika. Now that she's killed Romika, she ain't a danger to the community. She ain't a problem. Even if that's the case and that's the kit you working out of, bitch, she was a danger when she did it. And she's a danger now. If she will kill Romika in that manner, she will kill another woman in that manner. What you saying? She learned her lesson because she locked up and she know what jail feel like, so she'll never do it again? Just let her out and she'll be good? Bitch, it don't go like that. It don't go like that. You don't get to kill somebody at 9 in the morning with a 9mm. After you post it, sometimes you just gotta start killing motherfuckers and then decide, hey, everything cool, everything gravy, she not a danger, she killed who she wanted to kill, everything's alright in the world. This is some sick ass shit. Okay? Plaintiff appellee also pointed to section 6.1G7 of the statute, which focuses on whether the defendant is known to possess or have any weapons. Notably, Ms. Johnson legally owned and possessed her weapon. She had and she killed who she wanted to kill. So why would she be a danger and she free for killing Romika? Okay? This is, let me be clear. Let me be clear. Because I don't want anybody to have this misconstrued. This right here, wait a minute. Where's my highlighter? That's what I wrote, okay? This is what she wrote. Notably, Ms. Johnson legally owned and possessed her weapon. She had a valid FOIA and CCL at the time. And I say she killed who she wanted to kill. So why would she be a danger and she be free for killing Romika? This is what I wrote. This part in between, okay? So then she says, where plaintiff appellee relies on People versus Batty, or body to support the court trial ruling in this prong, and Batty, the incident was seemingly unprovoked. The defendant unlawfully possessed a machine gun and used it to shoot the victim. The defendant then fled after the shooting. In the present case, Ms. Johnson was not free to leave and remove herself from Romika's relentless violence and aggression toward her. That bitch was free to go wherever the fuck she wanted to. Let me tell you how I know. This is some bullshit. Let me tell you how I know this is some bullshit. Okay? This how I know that this is some bullshit. Okay? Because Holly got a 9mm with hollow points in that motherfucker. Now, Holly the only one that we know of out of all the witnesses, all the people on the street, right? All the people on Cermak, Carlos, Romika, the witnesses, the people going up and down the street, and all that. Quadajah the only motherfucker standing there with a 9mm Glock with hollow points in it. If you want me to think that she was not free to remove herself from Romika's relentless violence and aggression, that bitch got a 9mm Glock with hollow points. She can walk up and down Cermak and she run that motherfucker. Bullshit. She got a 9mm with hollow points in that motherfucker. She's the only armed party walking around. Quadajah the bitch with the gun. Quadajah the bitch with the 9mm Glock. Quadajah the motherfucker with hollow points bullets and a 9mm Glock, and a motherfucker wanna put in his goddamn court motion that she wasn't free. That bitch was free to leave the scene. That bitch was free to make any other motherfucker leave the scene. That bitch was running the scene with a 9mm at 9 in the morning. That motherfucker could have made anybody on Cermak do whatever the fuck she wanted them to do. Stop me when the fuck I'm lying. Stop me when the fuck I'm lying. She the armed person on the scene. Quadajah Johnson is on Cermak with a 9mm with hollow points in that motherfucker. She is running the scene. She is running the show. She is the aggressor. She is the motherfucker that can make any motherfucker around her move. Because at this point, she is holding the deadly weapon on anybody out in public. You ain't gonna tell me that a bitch with a 9mm can't go where the fuck she wanna go and do what the fuck she wanna do. Enough of that shit. Enough of that shit. She's the only motherfucker on Cermak that was free to leave, free to go, free to remove herself, free to be violent or not be violent. Because she was the one holding the deadly weapon. She was the one holding the deadly weapon. She is the person that is supposed to be the responsible one. Because she has a CCL. She's supposed to be the responsible one. Because she went to court like a fucking fanatic and get denied an order of protection. December, January, February, March, April, May, even in June. Even in June, when Romika was present on the court zone, the court still denied her request for a stalking no contact order. Because no stalking, first of all, had fucking occurred. Romika had one time been accused by Holly of coming to where the fuck she lived at. No stalking had occurred. Okay? So then she goes on to say, the deceased physically attacked Miss Johnson and rushed towards her before Miss Johnson fired 3 shots. If she physically attacked her, why ain't she called 3 digits? Instead of firing 3 shots, why ain't she down 3 numbers? The witnesses did. The witnesses did. She didn't want to do that. She didn't want to do that. She was attacked. Why didn't she take her gun off and say, back up? I want to leave. Everybody get the fuck back. Everybody get the fuck down. I want to leave. She ain't do that. She was free to go. She was free to go. Do you think, would you stop a motherfucker? I ain't stopping. A motherfucker pull out a 9mm, you could take my motherfucking car. Fuck you mean? She wasn't free to go. And a motherfucker got a 9mm. She free to do whatever the fuck she want to do. She could have stopped. She could have took that 9mm and stopped any motherfucker driving down Cermak and took their motherfucking car. So how in the fuck wasn't she free to get in her car and leave? How wasn't she free to get in her car and leave? Then she go on to say, Miss Johnson's gun was a lawfully owned handgun. It don't matter if that man had a machine gun and she had a lawfully owned gun. It wasn't lawful for her to shoot like she did. And she took a class to know the difference. She took a class to know the difference. Okay? Then she say neither did Miss Johnson flee the scene, but stayed and was cooperative with the police. If she was able to flee the scene, why the bitch ain't just leave? You saying that your client could have fled the scene. If she could have fled the scene, she could have fled before she killed Romika. If she was free to flee the scene, but stayed and cooperated with the police, she was free to flee before then. She the motherfucker with the gun. Who the fuck finna stop a bitch from leaving in her own car with a 9mm? Huh? You ain't finna stop a bitch from taking your car and leaving in a motherfucker and she got a 9mm. Huh? You gonna stop a bitch from getting her own shit and leaving with a 9mm? Okay. Okay, Ari, I believe you, girl. I believe you, girl. Yeah, girl. I believe you, girl. Okay. If she would have left the scene, Ari, if she would have left the scene, the police would have lit her ass up. They would have lit her ass up. If Holly would have left and got on the expressway and headed back to Waukegan after doing that shit to Romika, the state police would have fucked her up. That bitch wouldn't have made it home. That bitch would, hell no, she ain't free to sing. Cause she knew damn well if she did that there, that bitch would have been the scene. She would have been the scene. Where was she going? The witnesses was on her ass like a motherfucker, so where was she going? Where was she going? Her gun ain't even shoot no more. Her gun, look how God did the bitch. Look how God did the bitch. Her gun didn't even shoot no more. And you see how hostile the witnesses got with her motherfucking murdering ass? Where was the bitch going? And like I said, if she could flee after she killed Romika, she could have fled before she killed Romika. Fuck out of here. Okay, y'all. Plaintiff appellee also focuses on Miss Johnson's lack of a criminal background. Did we not hear this bitch background of fucking with the four corner hustlers? Did I not go over the bitch background of trespassing? I'll make sure I post her case for trespassing on land. Okay, so the bitch got a background. Don't act like the fuck she don't. Okay, she got a background. We seen her background. Okay? So, bullshit on the lack of criminal background. And then she said, claiming that Romika was simply arguing with Miss Johnson and that Romika never physically threatened her. Plaintiff focuses on Miss Johnson's lack of a criminal background, claiming that the deceased was simply arguing with Miss Johnson and that the deceased never physically threatened her. Those physical threats is the only thing y'all keep reverting back to, and that's what the bitch was saying to the courts when she went down there for that civil no contact order that wasn't even criminal, bitch. So those are just words that's highly. Why didn't you get a police report? Let's get to that part. Because motherfuckers been talking out they ass about all these police reports. Where the police reports stand? They was talking shit to each other. Okay, nobody gives a fuck. Those are just holly words. Show me a police report. Show me when the bitch went down to the police station and said it was true. Okay? Plaintiff appellee further cited to People versus Clark. And this citing is to suggest that the court rejected a claim of self-defense because the defendant posed a safety threat in shooting an unarmed person in public after an exchange of words. Isn't that what happened? Didn't she shoot Romika after an exchange of words? Absolutely. But she says that Clark is distinguishable from the case at hand. How? Because in Clark there appeared to be no imminent threat to the defendant. And so there was no imminent threat by Romika. If it was so imminent, it would have been an imminent motherfucking shot. It would have been something that occurred. Something that's tangible. We wouldn't be talking about her hair was messed up. Her hair was disheveled. But every single strand of them braids is in a ponytail. And ain't no motherfucking strands missing. Okay? So there was no imminent threat to Quadajah either. How was it an imminent threat to the bitch who got the gun? Romika's unarmed. She's not. I wouldn't give a fuck if it was Quadajah versus Mike Tyson. Mike Tyson can't beat no motherfucking hollow point bullet. Romika could never be the aggressor because she was unarmed and this bitch was armed. That's how I know. She could never be the aggressor because Quadajah was the armed person on the scene. And Quadajah knew she was the armed person on the scene. I wouldn't give a fuck if nobody else knew till she pulled out the gun. That bitch knew. She knew what she was working with. Okay? And so she goes on to say, defendant shot 8 times and fled the scene, and defendant was also on probation. Alright, we know that Holly ain't shoot 8 times, that she only shot 3 times, but she shot till she couldn't shoot no fucking more. She shot till she couldn't shoot no fucking more. And we also know, right, that she wasn't on probation. Because if she was on probation, she wouldn't have had her CCL or her FOIA card active. Okay? So, you want to call out that shit, that's not the point. The point is that an unarmed individual was shot multiple times. Okay? What is y'all, man? Y'all talking about it in chat. Hold on. Let me remember my last little paragraph. Because y'all cutting up. Who's the Galos? Yeah! I'm not in law school, okay, Pops, but I got an aunt who's more than willing to pay for me to go get my JD, okay? Maybe she'll sign the loan. She says she gonna help me out. But it's 3 years if you go aggressively. I don't know. Let me get my health together first. But let's finish this up because we almost done, right? Miss Johnson? Did we read this Clark part? Right, okay. Ms. Johnson, on the other hand, has not given the courts a reason to believe she would not comply with any conditions imposed, nor that she is a threat to the safety of others. Like I said, all that saying is, I'll be good, I'll kill who I want to kill, I'm okay now. Bitch. No. She spent 87 days not in custody without fleeing the state. She ain't had no money to flee. The bitch gets SNAP benefits. Where was she fleeing to? Where in the fuck was she going? She done gave all her cash to Raphael, so where in the fuck was she going? But didn't her auntie say that she was out of town and had a right to be out of town when we seen her getting in a hot tub or standing near a hot tub out of town during those 87 days? So the bitch did go out of town. She just came back, right? Right, Tamika? Right? Bitch, I don't forget nothing. Okay? She ain't got money to flee. Okay? She gets SNAP benefits. She swiped that motherfucking card and get some chips on the run. She going to jail. Okay? She swiped that motherfucker. You can swipe your SNAP in all 50 states. Okay? She swiped that motherfucker in Puerto Rico. She going to jail. Now you're saying she was also compliant with police on the date of the incident as well as during subsequent investigation into the case. They talked to her the day of the incident, probably checked in with her. She thought she was in the clear. She had people saying the case was motherfucking closed when all the time the case was not closed. So what in the fuck are we really talking about? Okay? Her being compliant. I bet if she knew they was coming to come with us, she wouldn't have answered the motherfucking door and left out any extra door she had only to run into them. I believe she only got one door in and out them type of apartments. Miss Johnson does not have a background in violence, no, but she got a background with motherfucking four corner hustlers and a pistol being involved. She got a background with trespassing on land is involved. Miss Johnson, PSA coincided with a level 3, so what? So what? She's calm now. She killed who she wanted to. Let's be clear. There is sufficient evidence to conclude Ms. Johnson's lack of real and present danger to any persons or community at large and such evidence should be greatly considered by the court. The only thing they need to consider is she killed who she wanted to kill, and she is cool now. That's all that shit's saying to me. In People versus McDonald, the defendant was charged with first-degree murder of his 3-month-old child. Now that's okay. We're talking about a 3-month-old, all right, and their child. Defendant brought an appeal after the court order was entered to deny him pretrial release under the Pretrial Fairness Act. One of the arguments the defendant made on appeal was that the state failed to prove by clear and convincing evidence that he posed a real and present threat to any person or the community, and that no conditions could mitigate that threat. This person killed their child, or their child died while in their care. Don't know what the story is, not finna look up the case. Don't think it was a gun involved. What does that have to do with this bitch being out in the community at 9 a.m. with a 9mm shooting up and down the motherfucking street? Like she had no choice. Then check this out. It said ultimately the appellate court found the trial court findings to be against the manifest weight of evidence, where defendant was 40 years old, had no criminal background, and continuous employment, served as a church deacon, and lived next door to his mother and brother. There was no other indication the defendant would be exposed to or responsible for the care of the children. So evidently this probably happened while this child was in the person's care, and it was the person's child. Has nothing to do with this maniac, Quadajah Johnson. Okay? Nothing to do with her. And here it is. Here Miss Johnson is. Y'all see this? Is a 31-year-old pregnant woman. When the fuck is she pregnant again? When is she pregnant again, y'all? Ari just made this motion. Can you tell me when the fuck Quadajah is all of a sudden pregnant again? I thought she had an abortion. I thought that, she had to do what was best for the baby. How is she pregnant? Now her lawyer saying she's pregnant. How? I want to see a test. I want to see a test. Here Ms. Johnson is a 31-year-old pregnant woman with a child of 1 that had also been gainfully employed. Ms. Johnson gained acceptance into dental school, a 12-week funky-ass program, okay? Ms. Johnson has no criminal background of violence, nor is there any evidence to suggest Ms. Johnson will commit the same offense is released. Nor is there any evidence to suggest Ms. Johnson will commit the same offense if released. She gonna kill Romika again? She gonna kill Romika again? Recommit the same offense? Who else she gonna murder? She would. She would. For Carlos, she would. For that nigga, she would. She would. Give her the gun and the time. Yes, the fuck she would. Yes, she would. Why does she have to do it again? Why give her the opportunity? Ain't once enough? Ain't once enough? That's the problem with the fucking system now. Letting people out to do the same fucking shit. We hear over and over about this person that robbed somebody, did this, and they done let their ass out on pre-trial release, and they done did some more dumb shit. Or killed somebody. Again. Fuck her. Why wasn't she being a mama to her child? Why was she out here instead of why wasn't that bitch out there trying to get in her little 12-week program? She spent more time trying to get an order of protection on Romika than she would have spent going to that janky ass dental school. Plainly, Ms. Johnson does not pose a real and present threat to anybody in the community, and the state failed to prove its burden of clear and convincing evidence. How? And a bitch shooting up and down the street at 9 in the morning at a school. Therefore, the state failed to prove there are no conditions of combination or conditions that can mitigate the alleged threat posed by Ms. Johnson. Plaintiff appellee argued the statutory factors mitigate any conclusion that any combination of conditions can mitigate defendant's safety threat. Ain't nobody finna be putting that bitch on electronic monitoring and all of that. No. She don't know how to check herself. And she had a gun. They gave her responsibility. They said, here's a firearm. Here's a loaded firearm. You can walk the streets with it. We feel you're responsible enough to do that. And she said, fuck that. This is what I want to do. You can't do shit with nobody like that. Give her electronic home monitoring for what? She, like I said, she can't flee because she ain't got no money to flee. Okay? People versus Graham. Graham, on the other hand, is again factually distinguishable from the case and not at all on point. In Graham, the defendant was slapped in the face by the victim who began to flee on foot. And Robika ain't do shit to Holly. Okay? And then she says defendant chased after victim and fired multiple shots. She didn't chase Romika because Romika wasn't running. What she did was pulled her gun out of her vehicle and started to shoot and ended up killing Romika on purpose. Okay? The court found the defendant's conduct goes beyond basic expectations of society. Just like they said, Quadajah goes against societal norms. The bitch is not normal. Okay? Also concluding the nature and circumstances of the offense beyond mere elements indicate the defendant poses a real and present threat to the safety of the community that cannot be mitigated by the conditions of release. Same thing with Holly. In the case at hand, the deceased did not run or move away from Ms. Johnson. The witness said she did move away. The witness said she did move away. And neither did Ms. Johnson pursue the deceased or flee the scene. She didn't have to pursue her. She shot her from where she stood. And she didn't have to flee the scene. She couldn't flee the scene because the witnesses was on her ass. Okay? It was confirmed by an unidentified disinterested witness that Ms. Johnson and the deceased were hitting each other. Who? When? Who the unidentified witness? She says the deceased was the aggressor, whereas Ms. Johnson held the gun. The person with the gun is the aggressor. The deceased ran up and swung at Ms. Johnson. The deceased also rushed at Ms. Johnson when Ms. Johnson shot. What happened to the fight? What happened to the attack? You just said that shit a couple of pages ago. No, she swung. Oh, she ran up. Get the fuck out of here. It sounds like what the witness said. When she broke free from Carlos, Quadajah shot her. Period. Looking beyond the nature and circumstance and offense of the case, a person is absolutely justified in using force against another when they reasonably You see that one word, reasonably. That bitch not reasonable. She's not normal. When they reasonably believe that such conduct is necessary to defend themselves against imminent use of unlawful force. This was not thoroughly examined nor considered by the state nor by the circuit court when determining whether their conditions could mitigate the alleged threat Ms. Johnson is said to pose. Like I said, bitch don't get a chance to say, oh, I got my target, I'm no longer a threat. She already demonstrated she's a threat to society by shooting in a community at 9 a.m. with a 9mm that's loaded with bullets that not only explode upon impact but go 12 to 18 inches in depth into someone's body. In People v. Lopez, the court considered relevant factors about the defendant to conclude the state failed to provide clear and convincing evidence that conditions of release could not mitigate the threat posed by the defendant. There, the court acknowledged that the defendant possessed a loaded weapon in the vicinity of a high school football game. Someone having a loaded weapon in the vicinity of a school is different from a grown-ass woman, 30 years old, unloading a weapon till she can't shoot anymore by a school. She's not 18. She's not an 18-year-old kid with a loaded weapon by a football game. She a grown-ass woman, 30 years old, who unloaded her weapon near a school and didn't give a fuck who was walking down the street. Essentially, consideration of Ms. Johnson's age, employment, the bitch don't work nowhere. What do you mean age and employment? Where she worked, the bitch gets SNAP benefits and said she was going to motherfucking go to a 12-week fly-by-night dental program, and the bitch ain't even pregnant no more, but you got that shit in your motion. Your punk ass need to be sanctioned and disbarred. You need to be disbarred, because you know damn well your client ain't pregnant no more. You know she ain't pregnant no more, but you put that shit in your defense so they can boo-hoo about this bitch. Okay? Then you talk about her age and employment. She don't work nowhere. She gets snapped. She said so in her November ass shit to the court. In her lawsuit for Raphael, she broke down and she don't work. And ain't worked in years. We already know she got a criminal history. Okay? So what? She had a lawful gun possession. She used her gun and her gun license illegally. And her PSA because that's after she killed who she wanted to kill and think that everything hunky-dory in the world. Okay? So none of that shit is a relevant factor in determining whether she could be released with any conditions. She should not be released at all. Ever. These factors weigh in Ms. Johnson's favor of determination that conditions of pretrial release can mitigate any alleged threat posed. The state failed to thoroughly consider these relevant factors and erred in its determination, and there are no conditions or combination of conditions that can mitigate Ms. Johnson's alleged threat to the community. And that's the conclusion. And ain't. The conclusion is the state failed to prove its burden by clear and convincing evidence. Ms. Johnson should be detained pending trial. And this court should reverse the trial court's order to keep Ms. Johnson detained. Wherefore, the defendant appellant Quadajah Johnson respectfully requests that the Honorable Court vacate the trial court's order for pretrial detention. And that's all, y'all. And you see that it had to be fewer than 4,500 words because they ain't finna be listening to all them goddamn lies. Okay? So we know that this bitch ain't pregnant. We know that this is all bullshit, and I'm tired of hearing it. Brielle said, imagine how many children are traumatized from witnessing this, whether they actually saw it, gunshots, or just know what fellow student mother's life was violently taken in front of the school. Exactly. Exactly. How is this bitch still pregnant? Okay, thank you, Shalonda. How is the bitch still pregnant? She needs to stop. She needs to fucking stop. Okay? Employ that OnlyFans. Exactly. Where the fuck she employed at? Raphael still ain't paid the bitch her motherfucking money, okay? Being accepted at dental school. That bitch is not in dental school. The bitch was doing a 12-week program. Let me pull this shit up for y'all. Okay? What's the name of that funky ass dental school? Okay, hold on, y'all. This is where the bitch was finna go. Okay. Okay, this is where she was going. Okay? And it's on the court document, okay? Y'all see this bullshit? They try to make it seem like this bitch that went to Princeton Medical School like me, and she was going to pursue being a dentist, okay? Okay? They got a virtual event on 4/13, y'all. Sign up for the event if you're curious. It's a Ready to Change Your Life. Our 12-week hybrid program combines online learning and in-person practice. Weekly homework prepares students to master technical skills in Saturday class. Students spend 4.5 hours practicing hands-on skills each week in the actual dental office. By combining online learning and in-person hands-on practice, we offer the fastest path to becoming a high-quality dental assistant. Now, bitch, 12 weeks, most people go and do this in 18 months to 2 years. Okay? Then you go 40 hours, which is 1 week basically, in the real world externship. That's the difference between an internship, because you know when doctors do interns, it's for years. Externship is shorter than that. An externship, I don't feel should be 40 hours, but whatever. Whatever. And students at Chicago Dental Assistant School able to begin their externships after class 3. So you go to class 3 times, you able to start your externship. School only 12 weeks. Learn and earn in 12 weeks. Okay? You get a basic life support certification. I get that shit through CPR. All you need to do is take a CPR course. What else you get? Shit. This janky ass shit. So they need to stop the cap. Like she an upstanding citizen and she's going to be a fucking dentist and she's just completed and matriculated from medical school. The bitch can't spell. She a fucking hoe. Oh, only the fuck fans. Alright? She don't even sell them nasty ass lashes now. Alright? Shit. Okay, y'all. Have a good rest of y'all babies. My stomach growling. I need lunch. Thanks for joining me. Have a good one. You know, stay on the same side. Okay? Stay on the same side. Thanks for joining.